you're doing and therefore know what we are going to be talking about. It's really doubly exciting for me to introduce Brian Preston, or if I may use his full title, the Honourable Justice Brian Preston AO. He's just been made the Order of Australia, or AO, which is the Australian equivalent of the Order of the Garter. It's serious stuff. And he is Chief Judge of the Land and Environmental Court in New South Wales. Visiting professor or at virtually every academic institution. I think he's going to Durham University, but he's done Oxford, done Cambridge, done them all. And he's also a fellow of the Royal Society of New South Wales, so seriously eminent and knows his stuff. Not least was, we always have to do a book plug. This one you guys have got to buy, because it is the first in Europe, I think, first proper legal textbook about net zero and the environment and nature positive. But we were slightly trumped by Brian Preston, because he wrote Australia's first book on environmental litigation, published in 1989, which was roughly the time when my youngest child asked me the All Souls question when I sat him down to tell him the facts of life, not the facts of life you're thinking about, but the facts of life about climate change. And he asked the All Souls question, how long have we got? Well, I hope Brian's going to tell us by the end of his talk. I've looked at his slides. They are absolutely fascinating. And Brian knows everything there is to know, not only about the subject, but also about teaching. So, Brian Preston. Just,
stand up, then I can actually see this.
You want to come in here? Maybe you want to come in here?
Yeah, this may be just easy, just to, otherwise I'm going to end up
Yeah, please.
lacking a swivel head.
Yeah, I'm not going to.
Okay.
No.
So you're going to hear more about this wonderful book, which includes both net zero as well as nature positive. I just want to sort of firstly set a scene for this and then raise some questions about what it means to achieve net zero and nature positive outcomes in law. So what are we talking about with net zero? Well, as the name suggests, it's about reducing carbon emissions to a level where the residual emissions can be absorbed and durably stored by nature and other carbon dioxide removal measures. So the goal of net zero emissions is to leave zero emissions in the atmosphere. Now, that's not zero carbon, because we're always going to have that, but we're matching what the emissions we put in with what we're taking out. Now, what about nature positive solutions? Well, they're actions that go beyond the conservation of nature to restoring and regenerating nature. So they aim to halt and reverse nature loss. So equivalent to what we're talking about with net zero emissions, we're trying to conserve nature, but we're also trying to restore and regenerate it so that we get an equilibrium there. Now, both of these can be seen to be environmental outcomes, and they're clearly good environmental outcomes. Indeed, they are essential environmental outcomes if we are to tackle the triple planetary crises of climate change, biodiversity loss, and chronic pollution. But as lawyers, we're not only interested in environmental outcomes, we're interested in legal outcomes. So what we can say is that, notwithstanding the desirability of these environmental outcomes, they're not likely to be achieved unless they're translated into being legal outcomes. So how do we do that? Well, of course, we need the law to command that these environmental outcomes are to be achieved. Now, how can we achieve them as legal outcomes? Well, the risk of oversimplifying the different means that law uses, I'm going to pick upon two. One is to create a right, and the second is to impose a duty. So the first, the right, is a right of someone, something, to achieve the outcome, and the other is the converse. It's a duty upon someone to achieve that outcome. Now, those two means are related. So if we think of Wesley Hofield and his correlative concepts, he's observed that the word right is used in at least four senses: right, liberty, power, and immunity. And it's the first sense that I'm going to focus upon, and that is the claim right. Now, the correlative of those four senses of right are duty, no right, liability, and disability. And so the law can create and give force to any of these dual relationships between, for example, claim right and duty, or power and liability. The most commonly invoked dual relationship we see in environmental law is between claim rights and duties. And so that's what I'm going to focus on. But one could also do this analysis with, I think, the power and its correlative of liability. But I'm going to use the duty and claim right and duty. So we can see that, and the book goes through a number of laws which look at these particular outcomes of net zero and nature positive. But what we can see in those is often a focus on the duty, but there will be a correlative in the claim right, because somebody has to be able to enforce that. So what I want to do is to go through, perhaps in theory, what the law, I say, needs to address if it is to effectively both confer a claim right and impose a duty. So a thought experiment, when you read the book, you buy it and read it, is to go through and evaluate the effectiveness of those laws. So you will see laws which say we are to achieve net zero by 2050, for example. But often those laws, as I'll say in most cases, those laws will be very short on saying how are they going to achieve that. So it sets the outcome, but it doesn't really go through how we're going to achieve it. So what I want to do in this address is really raise the questions which I think the law should be addressing if we are to effectively achieve these legal outcomes. Let's start with the claim right. And I suggest these are the questions we might get that off, because people are they going to be this is the last point. If you can't read it, sorry. So I won't read these out because I'm going to go through each of these questions. So the first is, who's the rights holder? Now, when we're thinking about rights, we're mostly thinking about human rights. And so the obvious answer to the question might be thought to be humans. But now we have to come down to, well, which humans are the holders of a right to the environmental outcomes of net zero emissions and nature-based solutions? And the answer may be, of course, different for each of those outcomes. Are we going to say it's everyone in the world? Are we going to say it's individuals who are directly affected by the non-achievement of the environmental outcomes? Are we going to pick upon particularly disadvantaged individuals? They could be the poor, the young, the elderly, or vulnerable. Are we going to pick groups or communities of people? Could be indigenous and tribal peoples or local communities. Or are we going to pick polities of people, such as nation states? We've got to, before we can even think sensibly about a right to an outcome, we've got to say who's the rights holder. But of course, do we want to stop only at humans? Can we say that a rights holder could be non-human nature? Of course, we will need a representative, a human representative of non-human nature, but it's still not legally impossible to have nature as a rights holder. Now we've got who is the rights holder, we've got to go to what the content of the right is. Now, you might immediately say, well, surely it's a right to the achievement of the environmental outcome. Well, how are we going to define what that outcome is? As I say, with what level of specificity or generality? Sorry.
Oh, maybe this.
Something's gone wrong.
Okay.
Yes, that's right. Thank you. So we could say, for example, with net zero, we could say the outcome is to achieve net zero emissions by a specified time. So we could say net zero by 2050 if we took the Paris agreements by the second half of this century. But we could also frame it more specifically. So two examples. One was Judge Ann Aiken in Juliana in the United States. I know it was overturned, but nevertheless, let's take that. A right to a climate system capable of sustaining human life is fundamental to a free and ordered society. And so that's picking up that one. Now that is echoed in the recent Constitutional Court of Korea decision, where they similarly found that the right to live in a healthy and pleasant environment under the Constitution created an obligation on the state, but we can see what the right is. Right? So we could formulate that net zero emission in a more specific way than simply achieve net zero by a particular time. But then, of course, we say, but what is the jurisdictional area within which that outcome is to be achieved? The net zero where? Is it the whole globe? Is it a particular nation state? Or some other area? So we can see that these questions about what the content of the right is going to flow through to not only the enforceability, who can bring it and whether the court has, jurisdiction to deal with it, but also the remedy for interference with the right. So then the next one, let's go to that. Yeah, thank you. The nature of the right. So I'm distinguishing between content and nature. And the reason is because if we think about human rights, there's a debate in relation to, for example, civil and political rights or economic, social and cultural rights as to their different nature, because that is going to affect how and when the right is to be implemented. I'll come to that in a moment. But we need to sort of say, what is the nature of this type of right? Yep, next one. Now, the next one is, when is the outcome to be achieved? I said that may be part of the content, that is to achieve an outcome by a specified time. But if it's not, then we need to put a time frame as to when it's going to be done. And as I said before, the nature of the right may just tell us when the time frame is to be achieved. So if it's more, a right is more in the nature of a civil and political right, then usually that sort of right is to be achieved immediately. But if we're dealing with rights that are economic, social and cultural rights, well, then they're usually allowed to be achieved when reasonably practicable and as resources permit. We're not going to be able to achieve a right to clean air or clean water immediately for all people. It's going to be implemented over time. So we do need to say this obligation to achieve net zero, when is it to be achieved? Because you can't begin to say when there is a breach until you know when are they meant to have done it by. Okay, so the next one is then, so what constitutes interference with the right? So as I've been saying, the content and nature of the right will affect whether there is an enforceable interference with the right. So if we thought that the right, for example, to net zero, is akin to a civil and political right, then any material failure to respect, protect, and fulfill the right will constitute an interference with the right, because it has to be done immediately. If the right is akin to an economic, social, and cultural right, and I suspect it is, then a failure to respect, protect, and fulfill the right will only constitute an interference with that right if there's been a failure to achieve what they would be defined, and would have to find this out, what are the minimum core obligations of the right? Because only then will you have an interference with the right. The next step is enforceability. So the law will determine whether interference with the right is enforceable, and if so, by whom and where it is enforceable. So obviously the content and nature of the right will determine the standing of persons to enforce an interference with the right. Now, obviously we've got rights holders, but we've got to see how those rights holders are have, what is the content of the right that they have, because only then can we see whether they're going to have standing. Now, if the right is a constitutional right, and mostly it's not, I can't think of an example at the moment where it's express constitutional right, unless you find it to be implicit within certain rights. So if there's a right to life or a right to a clean, healthy environment, and there are many constitutional rights which say that, you'd have to find that this right to net zero, for example, is implicit within that. That's what we're seeing in the Juliana case or the Korean case. There's finding within a more generalized right, a right to a stable climate system, which might be seen to be something to do with achieving net zero, because then by trying to get that balance between emissions and extraction from the atmosphere could be giving that stability in the climate system. So if it is a constitutional right, well, then all citizens, of course, have standing to enforce it. And that, if we looked at the comparatively recent Supreme Court of Montana decision held in Montana, could be seen that all the citizens had standing to uphold that. Go to the next one. But that's not universal, because we do see some of these rights having standing limited. So in the Swiss grandmother's case, the European Court of Human Rights denied the individual older women plaintiffs standing, yet to me, curiously, found the association of those individual women did have standing. Not particularly logical to me, but nevertheless, that was what they held. But you can see, therefore, that we thought the rights holders were the disadvantaged people, as I said, the old, the young, the women, minorities, etc. If they are the rights holders, then they ought to have standing. Yet here, the vulnerable people didn't have standing. And we can see an Italian case which the European Court of Human Rights denied standing to the individuals because they were outside the administrative areas designated as pollutant by the Italian authorities, despite the fact that the effects of the environmental pollution went outside those administrative areas. Of course, the administrative areas bear no relation to where the pollution is occurring. And yet, for standing purposes, they found a limitation in who are the people who could sue. The next question is, where are we going? So the law of standing determines, of course, who is able to enforce an interference with the right, but the law of justiciability determines whether any interference with the right, whoever is the plaintiff, is able to be enforced in the courts. Again, we need to go back and look at the content and nature of the right in order to determine the question of whether any legal claim for interference with the right is justiciable in the courts. So the more concrete and particular we frame the right, the more likely interference with the right will be found to be justiciable. But conversely, the more abstract and general we frame the right, the more likely interference with the right will be found to be non-justiciable in the courts. And the final question is then the remedies for interference. Now, the remedies will, of course, depend upon whether interference with the right is able to be enforced in the courts or not. So the courts will be able to grant the judicial remedies, but if it's not enforced in the courts, well, then the resources can only be had to the political branches of government to take whatever remedies they can do. But if it is justiciable, and so it's able to enforce in the court, well, then what types of remedies can the courts make? Can they make, injunctive orders? Can they make compensatory orders? It will depend. And as we're seeing in the justiciability cases in the United States, they are very much looking at what they call redressability, the extent to which they are redressable by the court. So remedy is essential to find out whether this is going to be a justiciable claim. Now let's turn to the duties. And so again, I've set out the questions in the next slide, which I will unpack. And here, I think we're going to, my thought experiment, when you read the book and you look at the laws, because a lot of them are setting out obligations, duties. And so I'd like you to think about these questions and to the extent to which the laws are answering these questions. I suggest if they're not answering them at all, or they're answering them unsatisfactorily, then that will go to whether we are actually going to achieve these desirable environmental outcomes. So let's start again with, this time, not the rights holder, but the duty bearer. So who is going to be the duty bearer? Well, one of the problems, of course, is when you look at these environmental outcomes, net zero and nature positive, they will only be achieved by concerted action by multifarious actors. As the saying goes, global problems require global action by all. But what does that mean? Does that mean that everyone bears a duty to take action? Every one of us sitting here is under an obligation? Logically, the answer is yes, but that's not what the law is going to do. It's going to pick a select few. But which select few are we going to select? Should the duty bearer be the government of the relevant polity, whether it be a nation state, a province or state, or a local government? But what about actors in the private sector? The corporations, such as, in the Miller Defensive and Royal Dutch Shell, case. Is it going to be, certain carbon emitters or extractors? But which actors are we going to pick? Which industries are we going to pick? And as I said, should corporations in carbon-intensive industries, whether it be carbon extraction or carbon emission, do they owe a duty to achieve the outcome of net zero emissions? But should we only look at, if they do bear a duty, should we only look at their own activities? Or should we also be looking up the supply chain and down the value chain? What responsibilities do they have to achieve net zero in their buying and selling of goods and services? And what about the financiers and insurers of corporations in these industries? Should they owe duties as well? They're enablers of those corporations, not achieving the outcomes. So there's a lot of questions there about who are we saying bears the obligations. Next slide. So now we go to whom is the duty owed? Now, if it's a true correlative, we could simply say, well, it's a rights holder. But many obligations in environmental law have no direct correlative. When we think of most obligations in environmental law, they impose either a positive or negative duty upon someone, but it doesn't immediately say that somebody bears a right. There will be a procedural right, that is, somebody may be able to take proceedings to enforce compliance with the duty, and in that sense you might say any person who is able to bring such an action could be seen to have a right, but it's not a right in a true Hofeldian correlative. Right? But it may be something which we could say. So if there is, in that loose sense, a statutory duty which doesn't have a correlative right, but nevertheless certain persons or groups have standing to enforce compliance with the statutory duty, it might be said that a duty is owed to that person. But let's test that. If we go to some of the recent cases, so going back to the Swiss grandmother's case, so there the European Court of Human Rights did uphold, as I said earlier, the standing of the Association of Older Swiss Women. So it could be said that Switzerland owed a duty to that association to take more ambitious climate action. We could say that. But then what about the Italian case that I referred to earlier, where the European Court of Human Rights denied standing to the applicant association to act on behalf of its members, who were the direct victims, although it was in a non-climate change case concerning illegal waste dumping. But does that denial of standing mean that denial that the government owed them a duty at all? An earlier case, not directly climate change, but the opposing factor case in the Philippines, where the youth plaintiffs standing to challenge government action over the over-allocation of logging licenses was upheld. And so one could say that the government owed a duty to uphold the right of those youth plaintiffs to a healthful environment. So whether that be a nature positive solution or not. All right, this one is to the content of the duty. And again, the law might prescribe the duty, but again, it may be expressed in rather general terms. As I said, we can come back to, as I was saying, the right. It could be just simply a duty to achieve net zero emissions, hopefully by some time. But it could also be done at a more specific level. So along the lines that the Korean court said that it's a duty on the government to achieve a stable climate. But if the duty bearer is a country, again, we need to ask the question, is it achieving this outcome, let's take net zero emissions, only in the country? Or is it also going to be in the country's supply and value chains? So let's go back to the Swiss grandmother's case. So there, it was held that Switzerland did owe a duty to reduce its greenhouse gas emissions, because that was what was interfering with the rights of the Association of Older Swiss Women. But the court also held that the Switzerland had to account for carbon emissions embedded in its imported goods. So that's raising the question of, does the duty extend to the supply and value chains in effect? So, for example, does Switzerland, if it has to purchase electricity from other countries, which is fossil fuel powered, gets it from Germany, for example, with lignite powered electricity, does it have to account for that? And what about the goods that it produces, the embedded carbon within that? Does it have to account for that? I mean, it's saying it has to account for the imported goods, but what about the exported goods? So we need to think about what is that content of that duty when we say there's a duty to achieve net zero emissions, And let's go to the next slide. Let's move from nation states to companies. So I mentioned the Miller de Foncy case. Now there, the district court in The Hague said that there was a duty upon Shell in the Netherlands to reduce its greenhouse gas emissions. But to what extent does that extend offshore to the Shell group? All the Shell companies operating in other countries. Now, the district court said there was an obligation. The Court of Appeal in The Hague said there wasn't. But again, we can see we've got to understand what we are saying. What does it mean to achieve net zero for a corporation? And we can say, well, what about, regardless of which of the Shell corporations in the group where we're imposing obligation, do they have an obligation to achieve net zero in their supply and value chains as well? Next is the timing. So we know the Paris Agreement says it's to be achieved by the end of the second half of this century. But what does that mean? Does it mean we can wait to 30 December on 2099? Or do we have to do it a little earlier? Well, we'll all be ruined if we have to wait to 30 December 2099. So commonly, it's thought to be the start of the second half, of the century, which is 2050. But that's not universally accepted. So if you look at China's NDC, they have a goal of achieving net zero by 2060. So others have taken 2050. But even 2050, is that too late? We know we are not on track to achieve either of the temperature targets, certainly not 1.5, and we may not achieve 2 either if we wait to try and achieve net zero by 2050. We may need to be doing it much earlier, 2030 or 2035, if we've got any chance of holding the increase in temperature to either 1.5 or 2 degrees. Right, let's go to the breach. Again, we have to think about what it means to breach. So obviously the content, how we define the content, will tell you whether you breach the duty. The more general the duty is framed, the less likely a breach of duty will be found. So you need a rather specific definition of the content in order to find a breach. But even then, there are breaches and breaches. What about if there's substantial compliance? Will that suffice? We know in many public law cases, substantial compliance is sufficient. And there is a test of materiality. How material is the breach? Because some will be accepted and some will be found to be unacceptable. So we need to talk about that. And then enforceability. So not all duties are enforceable. It will depend upon the nature and content of the duty. Now, one of the duties we see in environmental legislation is what John Austin talked about, of a duty that is one of imperfect obligation. So this is an obligation that has political force, but it doesn't have legal force. And therefore, there is no legal remedy by the courts for a breach of that. And we see that in a number of cases. I've given here two cases, one I was involved in, and was one in Canada, where there was an implementation, legislation passed to implement Canada's obligations under the Kyoto Protocol. And that was made against the wishes of the government and the then Premier Stephen Harper, and he just defied it. And there was no implementation of the duty at all. Went up through the courts, and the court said it's a duty of imperfect obligation. A breach of it has political consequences, but not legal. And so it wasn't enforced. So we need to think about what type of duty has been put in legislation. We don't make the assumption that just because it is in legislation, it is actually going to be legally enforceable. But if it is enforceable, by whom it is enforceable? So again, we come back to standing. Who has standing to bring action? So for net zero, every person is potentially affected, but does that mean every person has a right to enforce non-compliance with the duty? Or is it one where you need some special interest in the subject matter of the litigation? If so, what will constitute that special interest? And then we come to remedies. And the same questions that I asked in relation to rights will be raised in relation to duties. So again, it will depend upon what is the duty and where it is able to be enforced, because the judicial remedies that can be granted by courts will differ from the political remedies which can be granted by, say, the executive branch of government or the legislative branch. And again, we can ask those questions of what types of orders can the court make? And that will depend, as I said before, on the nature and content of the duty, and of course, the status and jurisdiction of the court within which the action is brought. That brings me to the conclusion. So what I've done is mainly raise a lot of questions, but these are questions we need to be asking, because otherwise there is the sort of mirage that we have a legal obligation because it has been put in legislation, but it may be one which is not going to ever achieve the outcome. And that's not so surprising. We have a plethora now of environmental laws, not so back in the 60s or 70s, but we certainly do now. And yet, on every single indicia, the environment is going backwards. So we have this perverse outcome. We have more environmental laws imposing more duties and rights, and yet the state of the environment is going backwards. Something's wrong. And I suggest one of the things that's wrong is, as I say, there is a mirage. We think we see legal obligations, but we're never testing whether they are effective. And that's what we need to do if we are to achieve these outcomes, which are very desirable of net zero and nature positive. Thank you.
One never wants to end with a mirage. That's what we're doing. I'm just going to come up with a definition, because one of Brian's points links into this, and I'd before we started noted page 902 of the book, and particularly paragraph 4.28. Why have I done that? Because it defines what's called embodied carbon. Now, who knows what embodied carbon means? I thought it would be the Rennie Prize winner. Well, it's in the book, and you need to know because it keys into everything. Embodied carbon is the amount of CO2 emitted during a product's entire life cycle, including raw material extraction, transport, manufacture, assembly, installation, maintenance, disassembly or demolition and decomposition. And of course, all of those will have rights, duties, and obligations of the type which Brian is talking about. So I'm next coming to comparative law. The British Institute of International and Comparative Law, also known as BICL, is a triumph of an institution. And it used to be when I was growing up that we thought English law was the best in the world. The people who pronounced on such a thing were not comparative lawyers, but we now have an institution of comparative law. And Dr. Ivano Alokna, who is our next speaker, is the Senior Research Fellow in Environmental and Climate Change Law. And he is going to talk about BICL's toolbox on corporate climate litigation project. And so I'm going to hand over to him. And I'm just going to go to the back and turn on some air conditioning. I know it's bad to do that, but I think otherwise well, thank you, Vikram.
Yeah, that's good.
Right.
Yeah,
Are we okay to start?
No, yeah, I just have to share it. So we share this. Yeah. So, yeah. Thank you very much. So, thank you for the presentation. It's an honor to speak after Brian. Thank you very much also for organizing this together. So, I want to talk about this project. As the chair was saying, is a comparative project at BICL. This is what we are doing, since the 50s, basically. I wasn't there because it's not that much time, and I'm a little bit younger than that. But yeah, basically, we are starting developing in the last years the environmental and climate change, in particular, work in our research. And thanks also to a part of 39 Essex chambers, we have started to develop this project that I'm going to introduce today. I mean, we are talking about somebody that is not here with us today, but because he's working on the other side of the world for a hearing. So I'm talking about Nigel Fleming, who is also one of the authors of this book. And Nigel is also part of our project since the beginning. I was telling about this story about how we started the project. So you know what I'm talking about to Alex here. So basically, in 2020, there was the presentation of a very interesting another project from the International Bar Association, the Model Statute on Climate Change Litigation. And by chance, Nigel and I, we were together at that event, but we didn't know each other. So basically, we had the same idea, and we discovered that a few weeks ago a few weeks later when we met. Basically, the presentation of the ABA Model Statute was to try and highlight the most interesting points about the current wave of climate litigation against governments in reality, and trying to see what were the lessons that they learned from the different legal systems. And I think you were also part of that project. And great other scholars and judges from all over the world. The only problem with this, if we can find a problem in this great project, is that it was just climate litigation against governments. So Nigel and I, we had the same idea that in a way there wasn't space to climate litigation against corporations. The reasons are many different reasons. I was trying to ask during the event to the speaker at that point, but it wasn't clear why. And then, there is International Bar Association on one part. There is the fact that it's true there wasn't so many cases at that point. And probably it was also quite delicate to talk about corporate climate litigation. At least we talked about that in these terms. Corporate climate litigation, the idea is to start studying a field that, yeah, we said could be a little bit delicate because we have to bring to courts these companies that a lot of people are defending, that are, according to a big part of the scientists, they can count for 70% of global greenhouse gas emissions from some part of the scientists like Rick Heady and his Climate Accountability Institute. And so we know that they are in a way responsible, if you can use this term, for that. But on the other side, they are also the kind of actors that we need to make this energy transition that we want to have to reach net zero and eventually nature positive. So yeah, this is the idea to do a comparative work to try and understand what we can learn from each other. So a similar idea, but of course coming from us. So this is something that we did in the last year. So we started in 2022, September 2022, and we put together scholars, judges, practitioners, scientists. We should say that in our methodology, we start to create the core group. So the core group is people like Brian Preston, Michael Gerard, Jackie Peel, Rick Heady, great judges, scholars, practitioners. Nigel Fleming is the chair of our core group, and others, Ingrid Goubet. So with really big experience, and they were a little bit, let's say, supporting our work because in a way, this is a very new field, and we were trying to find a way of making sure not to waste time, because this is also one of the main points when you do this kind of, basically what Brian said before, we have a problem that is related to, you know, the fast moving situation with climate change, but at the same time, we have to take into consideration that if we go against the governments, there is a problem that is regulatory capture. So is that effective? Because we were talking about effectiveness before with Brian. Is that effective to go and bring cases against governments? Or maybe is even more effective to try and discuss gently, politely, in a way that as lawyers we know how to do it, before courts, to try and push them to do this transition and to change their habit, their behavior. So yeah, we try to work with the first 17 countries that started to have this kind of litigation. So if you go on the BICO website, you will see it's called Corporate Climate Litigation Platform, which in a few days we will have in a new version. I will show you the preview, but basically there you already find all these 17 national reports, which are the fruit of communities of people. So we chose academics because I think that it was also important to show that this is an issue that has to be taken from a neutral perspective. And then we try to include practitioners, judges, scientists, economists also when necessary, for example, for the remedies part, to try and discuss with us and to try to discuss among them. And this is one also the interesting thing. We realize that if you want to create a global toolbox, which is a platform that could be useful for lawyers around the world to try and understand what their legal system can contribute and can learn from the others to make this kind of litigation more effective. And so to push better climate governance everywhere, we needed to do with a comparative methodology, with comparative law. So as you know, this is one of our thing to work with the comparative law. So these are the different reports. We went through extensive work of research through 3 axes. So it was basically all the different aspects of corporate climate litigation. We were talking about the different causes of action that could be used for this kind of litigation that have been used, but also, you know, a little bit about the prospects, what kind of causes of action we can use in each legal system, considering that each legal system has its own rules, it has its own, you know, different areas, also sometimes quite different, or sometimes a little bit also strange when we translate from one legal system to another. But so all the causes of action, all the procedural issues, including also standing, justiciability, and of course access to justice, and everything that is related to the procedural aspect of this kind of litigation, and of course the remedies. So we went through that with all these colleagues, and then we tried to do together a work of comparison. And so this is the toolbox. And we went also on by creating a dissemination of this. During this dissemination, we discussed in each country with all these different communities of lawyers and scientists and judges, and trying to understand if what we were doing could be improved, because this is an ongoing project and will continue. So yeah, you see, we are going to have next week and the week after, and a few weeks after, we are going to have the last two events. One will be in Washington, D.C., just, appropriate time. And we will be at the Environmental Law Institute, which, for reference, is like 200 meters from the White House. Okay, so there is already some people that say, you have really to be scared about being there, but we'll see. So that will be next week. Will be also online as usual. Most of all our events are hybrid, so you can also find the recording of the different events on our website. And next one, of course, you can imagine why, symbolically, the last event is the one that we are going to host at the University of Utrecht in the Netherlands, and we are going to discuss everything that relates, of course, to this evolution of one of the most important legal systems, at least from the point of view of crime litigation. So this is what we have done, and we have a great group of scholars. We have a great group of colleagues also here with us. And yeah, this is a little bit what we have done. And these are some pictures from our conferences. We organized 5, the 5th is the next one. We organized the regional summit. So basically, that was the Asian one, that was the European one. So Asian one was in the Philippines, this was in France, and the African one was in Nairobi in Kenya. And the next one, we don't have the picture because it's next week. And yeah, and we tried to create other outputs, because in a way, this created a lot of, let's say, interest, but also a lot of work. And basically now we have more than 200 people working with us from all the 17 countries. And in a way, one of the output also is we went from something like this, like a new blog that we created, Climate Law and Litigation. You will find on our website that was the first issue on climate litigation in the Global South. We thought it was really important to start by there, which is a little bit less, let's say, written in the literature, but at the same time, I think that climate litigation in Global South is probably one of the places where we are going to have more, let's say, satisfactions in the next years, starting from the Gary case, and then we are going to see what is going to happen in the next months with new cases. And then, of course, we, as part of our, let's say, dissemination, but as I said, is not a network. This is a working group that we created around the toolbox. We are, as always been done at BICOL, we create judicial training. So this is something that we keep doing, and this was part of our project. So every time that we organize a summit, we organize there also judicial training. And then we added some additional training for Asian judges, African judges. So this is interesting because make us create even more, let's say, partnership with other groups of people, other network of judges, to be sure that, in a way, if the judges know what they're talking about, what they're going to see in cases, in the climate cases, maybe there will be even, also because unfortunately, we cannot always have judges like Brian, a wheel of science. Here we have really the possibility of at least helping. Brian is doing his work since many years, going around the world and teaching that. We are trying to do our little part on this. So, and then, yeah, this is just about what we are doing, but why I'm showing you all this, because in a way, even with the podcast series that we are finalizing today, we recorded one with Brian and a judge from France, we are trying to convey all this knowledge that we are studying, that we're putting together, putting together people from very different legal systems, trying to understand how we can really learn some lessons from this. Because generally, to tell the truth, we know we are lawyers, we start studying in a certain legal system, and we are very comfortable with that, and it's normal. And then when we have to go a little bit beyond this, it might be interesting to have some references to the European Court of Human Rights, something coming from the international level, but we really do the effort to try and understand what the others are doing, what is the functional equivalent of what we do in our legal system. Probably not. So this is at least the work that we're trying to do to make sure to convey this kind of knowledge and to help you, to help all our colleagues that are working in this field. Yeah, this is a new website. So I just show you that it's going to be a little more interactive. Everything that is going to be there, even the toolbox, is going to be easy to access. So you will see there are like more than 30 sections, and we have this comparative analysis that is coming from all the different national reports, and all the different, part of this work are converging there. So basically you will find the webinars, you will find there this library of resources where you find all the knowledge. At least this is something that we are improving in the next months, but all the knowledge on this. And interesting also, there is, as I said, we go from the blog post to something like a Oxford Handbook on Corporate Climate Litigation that we're doing with other colleagues, Dutch colleagues by chance. And this is a place where we are going to have great scholars, judges, practitioners, scientists working together to give a global perspective of what we have there. And so we have, of course, the comparative analysis from the different countries, but we will have also the intersection with other areas and all these new areas that are becoming always more important, how they are influenced by climate change and how they can influence this kind of litigation, corporate climate litigation. And this is, I don't know if you ever heard about Climate Policy Radar. I think maybe Climate Policy Radar is a very interesting company. Is something that was created by somebody from LSE, from the Grantham Institute. And they are this AI company that's trying to create tools for law, for climate change. If you visited the Grantham Research Institute database, Climate Laws of the World, you have seen their work, because basically there we have a database where you can do a research in the different policy and laws around the world, and it's with AI. So if you're interested in something in China or in Brazil, they're going to retrieve the result even if you're writing in English. So they're going to find the pieces of the legislation, of the policy that are used there. This is very interesting. We are going a little bit over that. In this moment, they're working on the Sabin Center database that maybe is also the biggest database that we have at this moment, that is hosted by the Columbia University in New York. And this is a database where we have basically the US part, that is 3/4 of the cases around the world, and all the other countries, like more than 50 countries and other jurisdictions, that is expanding with everyday new cases that are coming. So this is a repository of cases. You will find like the synthesis of the different cases. It's really an important contribution from the point of view of the literature. And this is where we have the next work from Climate Policy Radar. The one after that will be our database, which is going to use the toolbox to help us, anyone, to ask a question, say, what can we do to do this kind of case? What kind of instrument can we use in any part of the world? Trying to use comparative law. And we continue also with short courses. At Pickle, as you probably know, we also do that. So we have the research part. We have also the teaching part. So we have climate law, climate litigation among the different courses that we are hosting. And this is like a course that we are going to offer open access in September to everybody about all the different aspects of corporate climate litigation. And I finish here, and I'm happy then when we finish to have any question.
Thank you, Ivano. Summer of 2023 was important in one respect, in that the late part of the summer, July, August, I went into Stephanie David's room, plonked myself down, and we discussed the creation of the book. And it's basically, as I said, I'm the vacuous front man. She was the driving force who engineered it start to completion, a little bit like the definition of the embodied CO2. She is now, I suppose, becoming a senior practitioner in chambers, and it is a powerhouse so far as public law, human rights law, and the like. But so far as this discipline is concerned, she's editor of the Environmental Law Review and a contributor to the Journal of Environmental Law. And if you really like podcasts, she hosts the podcast Climate Law Matters. And she is going to conclude our panel before we open to questions dealing with cases and the like. It's fairly broad, I think.
Thank you very much, Richard. Thank you. And thank you both very much for your very informative talks. I appreciate that. I'm not going to tell you what the book's about because you're very welcome to flick through it at the end of the session. What I am going to do is pick up on the point that Justice Preston made in relation to testing obligations, focusing on how they have been tested here in the administrative court and planning courts in particular. The reason I'm doing that is essentially to identify some themes that might assist in future strategic litigation and also inform cases in other jurisdictions. In terms of the categories of cases I'm going to be looking at, the first category is the economy-wide plans for decarbonisation and reaching net zero. The second are the sector-specific policy challenges. The third is the issue of climate change adaptation. And the fourth is how the law goes about embedding environmental considerations into policy making and individual decisions. So just to pick on the point that Justice Preston made earlier in terms of how we conceptualised administrative law here, I mean, in my view, it very much is a kind of duty question and a duty bearer question, who owes the duty? And so when we're thinking about this first category of cases, the starting point is the Climate Change Act, which I'm sure you're all familiar. The net zero duty set out in section 1. The Act also provides for a system of 5-yearly carbon budgets to ensure the net zero target is met, which again ties on the point that you made earlier, Justice Preston, in respect of the actual mechanism to achieve the kind of broader target, the obligation of result. So that's the main mechanism in the Act. In turn, it's really important to look at sections 13 and 14, because essentially those provisions require the Secretary of State to prepare policies and proposals that will enable the carbon budgets to be met. So that is the kind of ongoing obligation, section 13 in particular, on a particular Secretary of State to prepare, and then by section 14 to then present those policies and proposals to Parliament, which is a really important point that I'll come back to. So again, I'm sure many of you are aware of the kind of two key cases in this area. The first one was from 2022, which is in relation to the net zero strategy, which had been published in October 21. And that dealt specifically with the 6th carbon budget. It was found to be unlawful by Mr. Justice Holgate. That was a case brought by Friends of the Earth and others. On the back of that judgment, again, picking up the point about remedy, what Mr. Justice Holgate directed the government to do was to lay before Parliament a further report to remedy the legal deficiencies in the first report. And the way they did that was by producing the Carbon Budget Delivery Plan, which followed in March 2023. And indeed, that was then declared unlawful by Mr. Justice Sheldon in May of last year. Just very much in summary, so in the first case, the reason that Mr. Justice Holgate found the net zero strategy was unlawful really came down to this question of information that was made available to the decision maker, the Secretary of State. So it was information about the quantitative contribution that individual policies or proposals would make to achieve the emissions reductions necessary in turn to meet the 6th carbon budget. The context of that was that there was a ministerial submission that had gone to the Secretary of State, which referred to quantified policies and proposals only achieving 95% of the necessary emissions. The problem that Mr. Holgate identified was, how can the Secretary of State assess that analysis without knowing, first of all, what the delivery risk is in relation to individual policies, and secondly, the extent to which non or unquantified policies would make up for the additional 5%. The second case was in many ways very similar to the first, insofar as it concerned the question of information before the Secretary of State and his knowledge in approving the carbon budget delivery plan. The issue there was that, again, the ministerial submission, when interpreted reasonably, suggested the policy proposals would be delivered in full. That didn't reflect the true factual position, which is that it would only deliver 97% of the necessary reductions. And again, the deadline for the new Section 14 compliant report is the 2nd of May 2025. So again, watch this space and see how it plays out. And again, I'll come back, second half of my talk is to the themes to be drawn out of this case. So in terms of my second category of cases, it's looking at sector-specific policy challenges, which is obviously the logical consequence of thinking about an economy-wide approach. Obviously, the economy-wide approach must depend on contributions from individual sectors, and that is specifically set out in Section 13, where you're thinking about how different policies relate to different sectors of the economy, and you set out in the report that's been laid before Parliament. The jurisprudence in this area has not been very helpful. It's the global feedback case from December 2023 that specifically concerned the food strategy, which was a strategy that had been referred to in the net zero strategy as essentially the way that the government would support net zero, nature recovery and biodiversity commitments. But what the Court of Appeal found was that the food strategy does not fall within the terms of Section 13. It's not a policy or proposal for the purpose of that obligation. What the court also said was, in response to an argument that we made, which was that it falls on a particular Secretary of State, which is the Secretary of State for Energy Security and Net Zero. What we had argued essentially was Secretary of State is an indivisible office. It applies across government, and therefore it should apply to all government departments when they go about preparing policies and proposals. They have to also factor in delivery risk, timescale, so they can have and make an assessment. The Court of Appeal said no, that falls upon the specific Secretary of State, who can then make that judgment based upon how sectors sit against each other and work out on a kind of economy-wide basis. Next week, there is a case being heard, which is in relation to the challenge to the Jet Zero strategy, originally termed. It's a 4-day case. It concerns the strategy to decarbonise aviation. It doesn't include any direct demand management measures, but it is one, if you're around next week, you might want to come along to from Tuesday to Friday. And it'd be interesting to see really how the High Court deals with the global feedback strategy in the context of the statutory obligation not going as far as it did in the economy-wide approach. So another example of a sector-specific challenge that you might want to keep an eye on is in relation to the National Network's National Policy Statement. So essentially, this sets the policy framework for nationally significant infrastructure projects in the UK. It's important because it sets the need for such infrastructure, whether it's roads, whether it's rail, whether it's renewable energy plants, whatever it might be. And this specific concern of the client is roads. So the government decided to review this national policy statement in 2021 because of changes to climate change law and policy. Permission was granted in this challenge by Mr. Just in December. The principal focus of the challenge is the policy test in the new national policy statement, which essentially is that you can only refuse permission on an application for consent for a big road project if that one road project will materially impact the government's ability to meet the carbon budget. So across 5 years, across the economy. She observed in December, it's difficult to see how that test could ever be met in the context of one road scheme. And that's the week after next, again, the one to keep an eye out for. So the third category of cases, which I think is going to that grow is the question of climate change adaptation. There was an unsuccessful challenge to the National Adaptation Programme 3 last year. It was unsuccessful principally because of the terms of the obligations in the Climate Change Act. I mean, ultimately, adaptation is more about risk and objectives than very quantifiable emissions reductions. And essentially, that's what Mrs. Justice Chamberlain said. You can't adopt the reasoning from the net zero cases and apply it to the adaptation cases, because the first part of the Climate Change Act is very much concerned with hard-edged obligations, whereas the second part is much broader in scope. The fourth category is in relation to kind of embedding environmental considerations into policy and decision making. And again, this is another one to keep an eye out for. So this is the rights community action case. It's due to be heard in the Court of Appeal at the end of June, so 24th and 25th of June. The reason it's interesting is, again, tying on what Justice Preston said in relation to kind of lawmaking and legal frameworks. How do we use legal levers to ensure that environmental considerations are baked into policy making? And the way that, again, conscious that, sorry, adopting your approach of naming names, or a member of the audience was involved in the Environment Act, Ruth Chambers. So the Environmental Principles Policy Statement is obviously a really interesting and novel mechanism that was used in the Environment Act to ensure environmental principles can be embedded into policy making. There was a challenge brought by rights community action in relation to how this duty plays out. The duty is a duty to have due regard to the environmental principles policy statement when making policy. Mrs. Justice Lieben essentially accepted the defendant's submissions that you could do that after the fact, after you've made the policy, which would seem potentially counterintuitive, and it certainly counters the case law on equivalent due regard duties in the context of policy making and decision taking. She also considered that ultimately environmental issues are really complex, and therefore, how do you go about properly analysing how an environmental principle would apply in the context of a particular policy? But again, that's one to look out for, because I think it really will impact how the legal framework and the policy making framework is affected here. The other point to flag in the context of environmental considerations, see, you're all aware of the Finch case from last year. I'm not going to go into that. Safe to say, it does pick up the interesting point about imported emissions and exported emissions and how you go about dealing with that. Just in terms of a couple of cases, again, to look out for. So you may have seen at the end of February, in relation to the second runway at Gatwick, the examining authority has now reported, and that has gone to the Secretary of State. So it is worthwhile seeing how the examining authority dealt with the questions of greenhouse gas emissions. The other one to look out for is in relation to mega farms. So looking at the intensive poultry and pig units. So there's a development which is going to committee next week on the 3rd of April in relation to a unit with 14,000 pigs and 714,000 chickens. The local planning authority had originally scoped climate change out of the environmental statement, and the applicant maintained that position following Finch in their further documents in the autumn. Unsurprisingly, there are an extensive number of consultation responses, including from organisations like WWF, concerned about the climate impacts and the wider environmental impacts. So the climate impact, which is of particular interest, is the upstream emissions. So emissions from soya-based animal feed, when you have land use change or land use conversion in other parts of the world, the most obvious being in Brazil. And also the kind of wider environmental impact from nutrient pollution, slurry, and manure. So a few days ago, the planning officer reported and has recommended refusal of planning permission for the development, principally in light of the environmental information that's provided to date. And it's going to committee next week. So again, another one to keep an eye out for. So just in terms of drawing this all together, in terms of some kind of key themes, which I think are lessons learned and points to take forward to other jurisdictions, of tying in with what Ivana said in respect of what we can learn from each other. So the first one is this increasing emphasis on transparency and reaffirming the role of deliberative democracy in achieving net zero niche positive outcomes. And what I mean by that is really ensuring that, you know, lawyers can use the levers they have to get information out into the public domain, get it out to civil society, and to other groups that can actually engage in the debate. And that comes from really, you know, the net zero case, where Mr. Holgate specifically said that the reporting mechanisms under the Act are concerned with transparency and accountability, which then allows Parliament to do its job, civil society to do its job. So I think there is a growing emphasis and a growing trend towards transparency. And again, I think tying into, you know, the dissenting judgment in the Swiss case, which was obviously Judge Ike's view that ultimately this is a matter for democracy and other institutions rather than the courts. But again, I think it's a useful way of thinking about how litigation is developing, certainly here. It also ties into what Lord Leggett said in Finch regarding the role of environmental impact assessment. Again, it's the importance of proper environmental information so that individuals and groups can engage and participate in the debates around these high stakes decisions, high stakes in every sense of the term, in terms of environmental consequence, in terms of public benefit. So that I think is a growing trend here, and I'll be just hear views how it's operating elsewhere. The second is in relation to the importance of statutory interpretation. I mean, that's an obvious point to make in the context of administrative law. But it really does tie to the point again, just as Preston made, about how you define the duty. What is the duty? If it's a very general duty, how then can you enforce it? And what is then the remedy? And what's interesting is that when you survey cases from the last sort of 12 to 18 months, the most successful ones are the ones that have turned on statutory interpretation. So Holgate's case was the words will enable in section 13 of the Climate Change Act. The second case, which is Mr. Sheldon's case, there's one point I didn't mention earlier, which is he looked at section 13(3) of the Climate Change Act, which was considering how the package of policies and proposals will achieve sustainable development. And he honed in on the word must. You know, the decision maker must be satisfied that it will contribute towards sustainable development. What the briefing had said was essentially that is likely to be positive. He's like, well, that's not certain enough. You haven't satisfied that wording in the statutory provision. And of course, in the Finch case, ultimately that turns upon direct and indirect effect, which are legal terms in the EIA regime. So it goes without saying, but again, this ties into what we're saying about how you design law and lawmakers and the important role of lawmakers in ensuring that we achieve these outcomes. The third theme is what I think is going to be the growing role of expert evidence and science. And this point we've touched upon before is as the courts are becoming braver, we need to have the experts, we need to back up what's being said, particularly in the context of deference to expert judgment and that sort of thing. So can you say that the emissions reductions in respect of certain aviation policies are irrational? Well, they're illogical, they don't add up. You need experts to help you say that. And you also seen that in the private context, in the context of derivative claims under the Companies Act. I mean, certainly Lord Carnwath spoke about this when he analysed the Client Earth decision. He said actually so much is about the expert evidence underpinning your case to say actually what the directors have done wouldn't be discharging the obligations under the Companies Act. And the fourth and final point really is in relation to the potential, I'm a bit cautious about this point, is there's a judicial reluctance, I think, here to engage too much with human rights arguments in the environmental context. But I think there is a growing role for human rights arguments, particularly in assessing regulatory frameworks, which ties into the point you made earlier about how you then influence the private sector. I mean, ultimately, it is through those regulatory frameworks and levers. But I think that's an interesting area. And linked to that, I think one area that will grow is in relation to Article and Protocol 1. So private property in the context of impact on supply chains, but also in the context of climate change adaptation.
Thank you, Steph. Now we have a short period of time for questions if anybody has them. I do have a plant. Rather, the plant didn't ask the question because none of you had wanted to. Yes.
Thank you. Could I first of all thank Justice Preston for that very clear explanation of many of the key concepts in this area. Only a few are familiar to me from my dealings with public law, such as standing and justiciability. But what troubles me really is whether the outcomes you've outlined are achievable or possible in the current political turbulence and increasingly bellicose atmosphere. I'm sure I don't need to go into too much detail.
We won't talk about personalities, Brian, but I'd like to hear what you have to say.
Yes, it's always difficult to move from the aspirational statements into action. I think one way which we can take action is becoming more specific. Because when you break a big task down into, small steps, it seems more manageable, but it also seems less political. And when you think about the rhetoric of politicians around the world about, climate change, it's often at the high level. And so we say this is sort of, climate change should be dealt with by the politicians, by the political branches of government. And that's not a matter for the unelected judiciary. We hear that sort of stuff. But when you drill down to a very specific statement about what's the content of a duty, or whether there's been a breach of a duty which is legally recognized, it's very hard to run that political rhetoric, because it so quintessentially seems to fall within the province of the judiciary. Isn't that what judiciary does? So I think one answer to how to deal with, as you say, the increasingly bellicose political rhetoric is to don't answer it directly, but to answer it by being very specific about what we are trying to achieve, because then it acquires the characteristics of a legally justiciable dispute.
Any other questions? I often think of environmental cases or people's coming on from what Brian Preston has just said. Sometimes there's the saying, sometimes you have to touch the pot to realize it's hot. And it looks to me as though there's going to have to be something politically, some understanding about how it goes specifically into somebody's personal life. Take a farmer, for example. Well, if he can't get on his land because it's flooded, the penny might drop at some point, but there's a cause and effect there. But there we go. Now, I said I wouldn't do the planted question, but we do have Vikram, so we may be able to avoid the planted question. If that's the last one, then we will then adjourn for drink. We're coming up to 5:30. Vikram, your question.
Thank you, Richard. So without having had huge experience in this field, I do actually have an environmental case I want to bring against some quite big companies, turns out. But one of the problems does seem to me to be the potential breadth of the liability if any of this stuff is right. And I just wonder if the panel has any ideas for clever ways of not frightening the horses.
Brian, you want to go first?
Yes, it was always that I think it was the American case, Ultramarines and Touche, where they sort of unlimited liability to unlimited number of persons for an unlimited amount for an unlimited time. Soon as you a defendant conjures that up, you get a very nervous judge not wanting to set that precedent. Again, my technique when I was at the bar would be to not try to cover the field, make this a very narrow particular case, and say in this case, Judge, you do not have to decide all of the parameters of this. We'll leave that for another day. You just need to do this. It's a bit like in negligence cases, where you're wanting to see to whom is the duty of care owed. You start with the known categories of relationship, employer, employee, etc. And then incrementally, you take a little step. And so that the judge feels that's okay. I can take that little step. I'm not starting to feel too nervous about that. And so you just say, we'll do that. And if they ask the question, but where's the next steps after that? You go, you don't need to worry about that. You're just going to take this little step, put up your hand, authorities to get you there. You can take it with me. And then the judge sort of writes that in. Okay, I'll leave that bigger question to another day. That would be my suggestion.
Case strategy is quite interesting. Thurgood Marshall was the legal director of the NAACP and argued Brown versus the Board of Education. That case did not come out of nowhere. It came out of an accumulation of small cases brought by Thurgood Marshall to incrementally bring the law to the point that Brown could be decided. And that's exactly what Brian is talking about here. Anybody else on the panel have a comment on what Brian said?
No.
Right. Any
Justice Preston.
yes? No.
So one theme that emerged obviously from the case of the
Plot,
book. The tension between different environmental outcomes, net zero, net positive, most obviously in the kind of large scale renewable energy projects. I was wondering how you'd factor that into your analysis, like how you reconcile that tension between different environmental outcomes.
In a particular case or in drafting?
Just in general, yeah, in terms of questions to ask or think about.
That is, in a sense, it's quite common. So we see this particularly in the objects clauses of statutes, where the objects will pull and push in different directions. And it's common to say that in the exercise of discretionary statutory powers, they should have regard to and preferably implement the objects. Smith and Eastello and other cases would sort of say this. But where there's a difficulty is when those objects pull and push in different directions. And that came up in a climate litigation in Australia, where the Court of Appeal, because at trial, the judge had found that the decision maker had failed to take into account and to implement and make a decision that was consistent with one particular object. But on the appeal, the Court of Appeal pointed out, well, how do you do that? Because there are other objects which say to do the opposite. And so the decision was consistent with some of the other objects. So how do you balance that? And said that is an evaluative decision, that decision makers have a latitude to decide which object they are going to be consistent with and what weight they give to any particular object. Now, recognizing that means that you have to be clearer in how you draft your legislation. And so there's a few drafting tricks to overcome that. One is for a tiering, so that you can have sort of primary objectives and then secondary objectives. And so therefore you make it quite clear that weight is to be given to the primary before you descend to the secondary, so that everything is not equal. That's one way. The second is the way in which you engage an objects clause and the substantive provisions of the statute.
Mm.
So there are degrees of engagement. You know, the loosest is they say nothing about the objects clause. The objects clause just sits in the statute, but it's never then referred to in any of the other substantive provisions. And that is actually very common, and it causes problems. The second way, sort of getting more engagement, is to say regard must be had to the objects, but how you have regard to it, it doesn't say. And so that's where it leaves a wide margin of appreciation as to, you know, how do you could take that into account. The next level of engagement is to start to say how you take it into account. And so you can start to say that there must be sort of a formation of an opinion of consistency or inconsistency with the objectives, so that you say that you can make a decision, but it must be a decision that is positively consistent with, you know, the objectives, or if you've got a tiering, with the substantive, you know, priorities objective. Or you can put it in the double negative, not inconsistent, whichever way you want to draft it. And then you can go even further to say an outcome must be achieved. So that, and that can be put in a sort of a negative way, is that, you know, you cannot make a decision to do X unless you are satisfied that this outcome will be achieved. So if we're wanting to net zero, we could draft, you know, the Climate Change Act in order to say that that outcome must be achieved. Otherwise, you can't do it. Now, we can say that with a fossil fuel project. You could say you are not to grant a permission to a fossil fuel project unless you are satisfied that that decision will achieve the net zero, you know, outcome, or the net zero strategy, or whichever, you know, referent you want to use. So there are ways in which you can overcome this problem. But you're right. You've got to first identify what that problem is, then come up with how are you going to overcome it.
Well, that was a brilliant answer. And although I said it was a planted question, it was planted with her to ask him unknowing. So it all came out with which is absolutely brilliant. Let's give a round of applause to the panel.